right, it's 2 minutes past 1, so we might get started. Welcome everyone to what I would call an occasional series of webinars from National Legal Aid. Before we start, I'd just like to acknowledge that I'm on the land of the Gadigal people of the Eora Nation and pay my respects to elders past and present, and acknowledge that everyone at the webinar today is on different Aboriginal land and that this land has never been ceded. For those of you who don't know me, I'm Catherine McKernan. I'm the Executive Director of National Legal Aid, and I'm really pleased to be able to, facilitate this webinar today, which is a series of presentations that were given at the International Legal Aid Group Conference in Harvard in June by a range of different people from different legal aid commissions across Australia. And given the availability of online technology, it just seemed too good an opportunity to miss to not share the really insightful presentations that were given at Harvard to our colleagues across the country. So it's a really exciting 1 hour and a half. We hope that it enthuses you and really inspires you and feels, it helps you feel good about the legal assistance sector and the work that you do. Gets you to think a bit about some of the challenges that we're all facing across the world and in the country in terms of delivering legal assistance, and perhaps inspiring you to think about some different ways of working as well. The format is going to be fairly straightforward. We will have a summary of the conference itself provided at the beginning, and then the 3 presentations by the different people who attended the conference will talk for about 15 minutes, and then there'll be time at the end for questions, so around 15 minutes. So we're going to use the Q&A function of Zoom. So for those of you who may not be familiar with it, you can type a question in at any point during the session, and we will use those at the end to create a kind of conversation about some of the issues that people are interested in hearing more about or wanting to discuss. So really feel free as you're listening to just put anything into the Q&A, and we'll endeavour to try and create conversation about it after that. This is also being recorded, and we will make this available on the National Legal Aid website as well. So don't take copious notes. You can return and review the recording as well as part of this. So I think that's really just the housekeeping and the kind of overview. So without further ado, I'm going to hand over to Gabrielle Canny, the CEO of the Legal Services Commission of South Australia, to provide an overview of the themes and issues that were discussed at the International Legal Aid Group Conference.
Hello, everyone. It's really nice to be here in this format to be able to talk about the International Legal Aid Conference. I've been very fortunate over a number of years to attend a couple of these conferences, and every time I go, I'm totally enthused by the work that's being done nationally and the work that we can do here in Australia. The International Legal Aid Conference is held every 2 years, and this year it was at Harvard University in Cambridge, Massachusetts. It attracted delegates from over 30 countries. It was really fantastic to see representatives from Australia who were present, and to have the opportunity to meet so many people from diverse backgrounds who are all incredibly passionate about access to justice. It was also good to meet up with people that I'd sort of met before, and people who are sort of presenting really sort of 5-star leading programs around the world that we can all learn about and then sometimes replicate in our own environment. 4 Australian presentations were delivered, which you'll hear about, as Catherine said, over the next hour or so. Across the globe, we have emerged from the COVID pandemic, but there are still many backlogs in courts in many countries. Some, it was much more extreme than others. While there's an enormous diversity in the justice systems globally, from mature programs like ours in Australia and brand new programs in emerging countries, the passion for access to justice across the country and from those working in this sector is so clear to see. It remains consistent. It should therefore come as no surprise. The themes and discussions from the delegates attending from around the world in and out of sessions had so much in common. The perennial issues remain: rising costs, rising demand, and lawyers leaving legal aid work. But in addition, the reference to people-centred justice as defined by the OECD framework and good practice principles for people-centred justice was a common thread. The place of so-called non-lawyers as proxy agents, navigators, and crisis navigators was discussed. In some areas, 90% of people who have a justice problem solve their issues outside of the formal justice system, and that's areas geographically, but areas also of the law. The cost of employing a lawyer and accessing the court system, as we know, is prohibitive to so many people. In the US, some states have embraced legal technicians who are able to deliver tightly defined legal work, but other states have banned the concept, so there's still quite a debate going on there. Discussions also included the need to consider redefining access to justice, where the focus is more on the vulnerability of people as a classification of need, rather than poverty. Also, adopting a holistic approach to service delivery, where we are not just looking at the law, but giving consideration to social, welfare, and health perspectives. As we know, Australia has embraced this mode of service delivery and in much of our Commonwealth-funded services. Housing security emerged as another international issue. This was prompted through COVID, but also now, like we're seeing in Australia, has become a bit of a crisis in many, many countries. In the US, for interest, I learned that your right to housing has emerged as what we would call a Dietrich principle here, in the sense that if there's any litigation over a right to housing, whether it's tribunals or courts, the individual must be represented. There can be no self-representation in that field. So that's an enormous sort of step forward, but it also shows in the US the urgency of the problem. There was no escaping the discussions on the rise of digital design and its application in service delivery. The emergence of artificial intelligence and the need for technology to be embraced was discussed at length, with lots of differing views and lots of levels of acceptance, rising from very low to completely embraced. The beauty of the ILAG conference is the speakers range from academics through to practitioners. And so we had that whole range of views, particularly, as I say, about artificial intelligence. All in all, it was a fantastic conference to be part of and to promote the world-leading activities being developed and delivered by legal aid commissions throughout Australia. I hope you enjoy the next presentations, and I'll see you at the end when I do mine. Thank you.
Thanks so much, Gabrielle, for that overview. And I think that you'll see that the overview that Gabrielle provided is actually reflected in the presentations as well from Australia. So it's good to see that there is lots in common across the world in terms of some of the challenges and also some of the innovative work that we're doing. Our next speaker is Louise Glanville, the Chair of National Legal Aid and the CEO of Victoria Legal Aid, and she is going to talk to the topic of what is the cost of not funding legal assistance. So over to you, Louise.
Thanks so much, Catherine. I'll have to say at the outset that I'm a bit throaty, so if I have to have a bit of a cough in the middle of it or a sip of water, please excuse me. I'd like to start by acknowledging the traditional land that I'm currently on, of the Wathaurong people down near Geelong, and to pay my respects to their elders past, present and emerging, and note that their lands have never been ceded. I also want to acknowledge the work that's happening at the moment in Victoria on the Yurruk inquiry, very important in terms of our self-determination down here and treaty listening and understanding, as well as truth-telling, and also the national work on the Voice. That is, we're soon to see, hopefully, the announcement of a date for that referendum in the next few days. It is great to be here as well, and I want to also say at the outset that the paper I delivered was, I did jointly with Martha O'Carlis, who's a colleague of mine at VLA, and we worked together on this paper, and I had the joy of presenting it. So essentially, I just want to give you a rough outline of what's in the paper. I tend to not use too many notes, so I'll talk more generally, and I'm very happy to take questions after all the presentations have been given. So this paper is titled, What is the Cost of Not Funding Legal Aid? and legal assistance in particular. So albeit that I'm the CEO of Victoria Legal Aid and the chair of National Legal Aid, this paper really had a legal assistance focus more generally. It takes a systems approach, and in taking a systems approach, it says there are three main things that government need to be thinking about overall. The first was how do you develop an orientation that relates to the funding of the whole system or the whole sector within which you're in or that government is considering. So how do you develop this notion or orientation? And I think this is a really important piece because what we know is that there are many examples where the legal assistance sector, for example, is not seen as being involved in the sorts of systems that are being funded that will have impacts for us. And perhaps the best example of this in recent years is on the national front with the family courts and the old Federal Magistrates Court, when there's a new case management system being introduced. And that case management system is funded by the federal government through, the appropriate bidding process that goes on from the courts to government for what they need and what it needs. The proposal itself is one that, for example, National Legal Aid really supported. We think it's a very good approach and we're keen to see it fully come into effect. But sadly, funding was given to the courts, but none to the legal assistance sector that was to support the work of the courts in their introduction of the case management system in terms of the sort of events that was going to happen as a consequence of it, the number of events, the way in which that was going to work. So it's a good example of the stewardship that's needed by both governments and departments in thinking about systems as a whole and sectors as a whole, and not just focusing on resourcing and funding for one part that may have quite serious impacts for other parts of the system. In that instance, we were able to advocate for more funding for the legal assistance sector to assist with that important reform for the courts, and that was a very good outcome for us. We didn't get everything we asked for, but we got enough to get us started and keep us going, and it'll be no surprise to you that we're back arguing for some more money for that currently. So that's the first thing that I think is important, is funding that reflects pipeline impacts. By that I mean federal level, if you're going to fund a court in some way and it's going to have implications for legal assistance, they're funded as well. At a state level, it might be more around things like increasing numbers of police, and so they're in a state, and so therefore the effort the police put into policing and what that means for people coming before the courts increases, and therefore that has an impact for legal assistance. It might be increasing the number of child protection workers in a state and what that means for the legal assistance. So essentially, it takes in those pipelines. It should also, in my view, take in demand. Demand-based funding is something that has been tried in various parts around Australia. I think New South Wales most successfully has been able to look at this more thoroughly in the criminal space. But it should think about demand in the context of not being a static thing. And in fact, demand, I think, for the people certainly that we see, really it consists of both legal and non-legal demand, and the two of these come together in a sort of connection between legal advocacy and non-legal advocacy, and I can talk about that a bit further on if that's of interest to people. It also needs to take account of population growth, and that's a pretty basic thing to say when you're thinking about funding the whole system and what it looks like. But population growth clearly is a very significant piece. I think in Australia, and that work's being done, of course, on the NLAT review now, but we really haven't seen an injection to core funding, for example, of legal aid commissions, speaking from my own experience, let alone perhaps other parts of the system, community legal centres, Aboriginal and Torres Strait Islander legal services, and also thinking about fees private practitioners are paid. We haven't seen an injection to the core of this funding for over a decade. In fact, I think for me, it'd be more like, if we're in 23 now, it'd be more like probably 13 years since we've seen a solid injection into core that takes account of these features. And finally, it needs to take account of, I think, things like the poverty line and what our means tests look like for who gets access to services. Because if you're in your jurisdiction, wherever you are and whatever role you take on, if it's like ours here, our means test is incredibly mean and getting meaner all the time. And what that means is that people who are experiencing poverty or disadvantage in some way are not necessarily going to be able to get the services they need from the services that we provide in terms of being eligible under the means test. So they're the sorts of things we think that the systems approach requires in terms of funding the whole system. Second thing that this paper advocates for is really thinking about the importance of co-designing with people with lived experience in all that we do now. I think this is nowhere clearer to me than if I look at the early results from the Public Understanding of Law survey here in Victoria, which is actually also being launched this week from memory, and looks at both legal need and understanding of law. And the most, I think, key feature from that perhaps is not surprising, but it's very up in lights for me, is that often people do not even know that they have a legal problem. So this is not something that they're aware of, that's something that's occurring for them in their life, either isn't already a legal issue, or it may emerge into a legal issue. And this means that the design work we do around delivery and how services look, how we think about early intervention and other things, really does need to be informed by those experiences of people and what we know about them, what the research tells us about them and their lives, and how we work with them very thoroughly to hear what they have to say and to use that material with their permission to actually improve what we do and how we respond to their needs. So I think that's an important piece. And the third piece that's, I think, relevant to this whole idea of a systems approach is really that the evidence we use to think about the systems in which we work, and particularly the legal assistance sector, consists of outcomes and impacts, not only inputs and outputs. And this, of course, is a far more it's a harder way, I think, to think, but much more thorough in terms of understanding what this will mean for people in terms of the quality of their lives. Here in Victoria, like I'm sure in many places, we still have what are called BP3s, which are budget paper 3s outputs, and they are essentially statistical sort of targets that might be reached in any given year in terms of the quantum of service delivery. That's important, but I think what is far more important is understanding what difference that has been made in terms of the individual who you're involved with, and the outcomes and impacts more broadly. So they would be the three areas that I think would cover that systems approach more thoroughly from our perspective. The second thing that the paper does is it explores the work of National Legal Aid, and it was commissioned by National Legal Aid about a year ago, and a report was delivered earlier this year on the cost-benefit analysis of legal assistance and what it actually delivers. Cost-benefit analyses are not an uncommon thing. I think many of you will be familiar with this piece. And essentially what this does is it looks at the economic benefit that arises as a consequence of delivering legal aid services. So this was a piece that particularly related to NLA and the legal assistance services that we provide through legal aid funding. That were funded by the Australian government and related to Commonwealth law. So it didn't take into account funding by state governments and also territory laws and funding as well. And in this report, and I'll just give you the highlights here, but I'm very happy to talk about this more. Essentially what it showed was that in the report we got in early 23, is that the provision of legal aid delivers more than 600 million in savings to the community, government and the justice system every year. So that's 600 million in savings to the community, government and the justice system every year. And that every dollar that's spent in delivering, every dollar spent delivers $2.25 if you want to put it in that way, in quantitative benefits. And it also underscored that the methodology that was used and the assumptions underpinning that methodology are very robust. So this is a result that I think is really worth looking at and reading about, because it is quite significant, and I think at NLA, we were pleased with seeing that was the outcome. It's always a bit nerve-wracking doing these sorts of reports, but we did it, and that was the outcome. Most importantly, though, for me, it also highlighted the non-quantifiable benefits of investing in legal assistance. And I just want to briefly touch on some of those. It started off with benefits to the justice system generally, and this relates to things like efficiencies in the system through the provision of legal representation, mediation, duty lawyering, and most importantly, I think in more recent times, early intervention services. And what it indicated, for example, is statistics around things like if at least one self-represented party exists in a matter, that matter takes at least 20% longer to resolve. So these things are giving you a sense of the importance of court time, in my view, and how court time is taken up and what that means for things like delays in matters, what it means for wait lists in matters, what it means for matters not getting heard for many years, which we particularly know is a consequence of COVID, although we are all now recovering from that in different ways. But that's quite an important piece, I think. And I think the unrepresented litigant proposition that puts there is not a new one to the legal assistance sector or to the justice system overall. People have been talking about this a long time and the impact of that on court proceedings. The second thing, that type of benefit that was outlined, was the benefits to individuals. So not only is it likely that legal assistance offers improved outcomes for individuals, but it also improves the livelihood and well-being for people by reducing often domestic and family violence, as well as anxiety and stress. So they were trying to capture how these individual benefits might look, not just in a dollar term, but what the more unquantifiable ones are that they can see in a qualitative sense that are important. And I think this then plays exactly into the connection between legal and non-legal supports. And many of us now know that the best services are designed in this way, and that not only do they involve deep lived experience from those that have used our services and can share that with us and can help us to be better than what we are in terms of our service provision, but also more broadly, I think taking account of the role of non-legal advocacy within legal and justice systems becoming such a potent and powerful way of diverting people away from legal systems in large part. The third area that they identified was benefits to government and wider society. And this was really recognition of improved outcomes for families, reduced need for out-of-home care, and improved mental health outcomes for individuals, but the impact of those for communities as well. And then also there was a sort of some comments around, as I've mentioned earlier, looking at the correlation between improved access to justice and reduced risk of conflict and violence. And I'll encourage you to read those sections, which are quite interesting to get that feel for how this is playing out. So that gives you a bit of a sense of what was in our report and what was found in terms of that figure, the 2.25, that remains quite important that we're using in advocacy in lots of different ways. So turning back to the legal assistance sector specifically, just a few things I wanted to mention there. Firstly, that if you think of the Australian population, we know now that 13% of people live below the poverty line. As I said before, only 8% of those would qualify for a grant of legal assistance. Now, my feeling is this figure is probably lower than what that 8%, but it gives you a bit of a feel for how mean the means test is. And I think this is something that we are taking up in terms of the NLAP. The review of the NLAP and thinking through, what does a civil society look like in terms of access to justice for people who may be experiencing some vulnerability or disadvantage in a variety of ways. Secondly, I think the focus on the legal assistance sector reminds us of the significant amount of unmet legal need we know exists in communities. Particularly want to reference rural and regional communities, particularly remote communities as well. And once again, I draw on that the work of the Victoria Law Foundation as the most recent population-based legal needs survey, just being completed now after interviews with 6,000 people. and the early information that's coming out about people having issues that are legal in orientation, but that the recognition of those not being there by the people that are whose issues they are. It's quite a dreadful scenario, I think, because it means that people will go deeper and deeper into the sort of systems we would wish them to be able to avoid in large part. And I think the other point that's important here in the legal assistance sector is this early access to support and the crucial role that plays in preventing escalation of more complex problems. So this, once again, connection between legal and social issues and legal advocacy and social advocacy is a very important one. To end with a few examples for you, I think some of the work that the legal assistance sector has done around bushfires and disaster legal help, as it's now called, is a good example of collaboration between various parts of the legal assistance sector. Has very much an early intervention focus, for example, focusing on people's circumstances before a tragedy or a disaster happens. So thinking about home insurance before bushfire season, thinking about the way in which communities bring together supports in disasters rather than waiting till the recovery efforts in place. Lots of individual things that can be done from a legal perspective and a social community perspective prior to just waiting for an event to happen. I think too about the early resolution services that exist a lot in family law and also in other services like in Victoria, Independent Mental Health Advocacy, the IMA service, which is a classic example of really effective non-legal advocacy that can link to legal advocacy when that's required. And this is a really important, I think, trend for us to think about if we are lawyers, or no matter who we are, thinking about those sorts of intersections. And I also want to point to particularly for legal aid commissions, the capacity to take the individual matters that might become apparent to us, either through telephone helplines or through grants of assistance, and that can help the individual who's coming to us, but can also assist the communities more broadly. And probably for me, the best example of that at Victoria Legal Aid is Robodebt, given that we ran the federal court matters which led to the unlawful finding of that dreadful practice by the former government. So in that way, I think the use of the legal aid dollar, or the use of funding, for example, legal assistance, can be of benefit to many, many more than the numbers of individuals that we serve. So that's another sort of important, I think, outcome we can have in the work we do in terms of strategic litigation and strategic advocacy. So finally, and just in conclusion, I'd say for me, the cost of not funding legal assistance is a cost that we all have to bear in so many different ways, and as individuals, in our communities, and more generally in civil society. And on that note, I think that the NLAP review, which we're all currently, or many of us are currently engaged with, which is looking at funding for legal assistance across the country, is a really important moment in time for us to be advocating the benefits of funding legal assistance and, in fact, the costs of not funding legal assistance. Thank you.
Thanks so much, Louise. That was a really short and sharp overview of the system, investment in the system, and the capacity of legal assistance to really make a difference to communities and people's lives. So lots to think about in terms of the National Legal Assistance Partnership Review and how we all might need to be thinking about advocating in that space. And I just want to remind everyone there will be questions at the end of this session. So if you've got questions for Louise, please feel free to type them into the Q&A and we will look at them at the end. So as you're listening, please feel free to type in any questions. We're going to move over now to a presentation by Jane Sippens, Director Client Services, Legal Aid New South Wales, and Ruby Steele, who was the Manager of Legal Service Development at Legal Aid New South Wales, but I think is currently an honest comment at the Department of Communities and Justice. And they're going to reprise their presentation, Is Access for All Really Access to Justice?
Thanks very much, Catherine, and thanks everybody. I am Jane Sippens, and we have Ruby Steele with us today, and we're going to present to you our paper that we gave at Harvard a few months ago. But in opening, I want to acknowledge that we're on the land of the Gadigal, who are the traditional custodians of the area, which is now known as Sydney, and who were dispossessed of their land in 1788. And we acknowledge and pay our respects to our First Nations colleagues joining us on this webinar. So Ruby and I are going to share a short story with you of a long journey. It's a story of how our clients taught us that so-called access for all is not really access to justice, especially for those whom we're meant to serve. I'll start the story with the words of a client in a review left on Google a few years ago, and then we'll tell you about what we learned and how we designed a form of legal triage. So the next slide, the Google review read, "When coming for legal aid, don't be courteous and let women out of the lift first, as it is a vicious race to the front desk." That review was dubbed the Hunger Games quote, and I'd like to say that it was an outlier, but it wasn't. So what was going on? The next slide shows that Legal Aid New South Wales is comprised of 28 officers serving around 30% of the Australian population, or 8 million people, over about 800,000 square kilometres. We knew from our staff across the state that there was significant demand for one-off legal advice services, and staff in each and every one of our offices were doing the absolute best they could to meet this demand, relying on teamwork, workarounds, and a mix of traditional and ad hoc approaches. We undertook field work to understand what was really happening. We observed and spoke with clients and staff in many locations to see how people experience our service at the front end. We talked with staff about the challenges they faced in delivering advice services with limited resources and increasingly complex needs of clients. We also looked at all the reviews and complaints that clients had made about our service. And we found a few things. Clients had difficulty accessing our services and often experienced a messy, confusing, and maze-like journey as they tried to get the legal help they needed. Clients often had to wait weeks for an appointment or were told to call or come back another day. In some locations, drop-in clinics were based on a first-in, first-served system up to a set number. And significantly, we discovered that 28% of our advice services were being provided to clients who had no indicators of being socially or economically disadvantaged. These findings revealed the hard truth that we simply cannot provide legal advice to everyone in New South Wales who wants it, and we need to be deliberate and transparent about who can access what level of service. In attempting to make short legal advice services equally available to every citizen of New South Wales, those who should have been prioritised for a service under our mandate were missing out. So the next slide, we knew we needed a triage model to consistently service people according to need. Triage in medical terms is simply a way of responding to and sorting people into groups so that those with the most urgent and dire need are prioritised for service. It is required because there are limited resources. We partnered with the Law and Justice Foundation of New South Wales to look at models of triage, especially in the legal sector, and the types of criteria that we could include. The LJF paper helpfully identified different models of triage, and we saw that we were unconsciously operating most of these models simultaneously at different sites. Models include first come, first served, lottery system, priority to worse off, or priority based on urgency. These models preference people in different ways. For example, first come, first serve preferences people who have the means and capacity to get there first. Without thinking it through, we were already applying triage criteria, but without deliberate intent and purpose, and most seriously with outcomes that did not support our Legal Aid New South Wales purpose. The first thing we needed to do, therefore, was to revisit this purpose and our duty laid out under our legislation, which is to help people experiencing disadvantage throughout New South Wales and make that help readily available and easily accessible. Next slide, thank you. Clearly, the existing universal service model for legal advice was not aligned with our mandate and was not allowing us to properly serve those people who were experiencing disadvantage. Immersing in our purpose enabled us to design a new service model. That's what you're looking at here, the reverse opera house. This took a year in consultation and gave us the blueprint upon which our last 4 years of work have been based. It clearly differentiates between universal, as in available to everyone, services, and individualised, available to people who are eligible, services, and places triage as the gate between them. The Legal Aid New South Wales client service model was launched in 2019, and the key features are universal services are available to everyone in the first arc and are defined and focus on making it easy for people to self-help and take the next steps. Legal advice provided by a lawyer is no longer in that universal layer. There is now a consistent triage gate to legal advice. We have differentiated between universal, individualised and intensive service layers with triage gates between each layer. Intensive is the smallest arc at the top and is where our specialist services sit. Our universal services, such as legal information, are being continually enhanced to expand and become more intuitive and person-centred. Our whole service model is grounded in the wider legal social services sector. We are opening new channels and streamlining existing channels for assistance, for example, web chat, statewide phone advice services, and a new website. Triage occurs when the client first approaches us for assistance, but also before progressing to each level of service. Now over to Ruby to describe the process of designing triage.
Thanks, Jane. Next slide, please. So we needed a way for our intake staff to be able to determine if the person calling or coming to the office needed legal advice or information only. Our triage model needed to apply to family, criminal and civil law, be simple enough that it could be applied by non-legal staff with very limited time, and be consistent across all our offices, including our call centre. We started by watching our lawyers giving advice, and we saw that the lawyers themselves were triaging to determine what level of service to provide. The two key criteria they were using to determine the level of assistance was the impact of the legal problem and the vulnerability of the client. Where both impact and vulnerability were high, the client would be advised and streamlined into a casework service. Where both were low, the lawyer would spend less time with the client and would provide basic one-off information and referral rather than legal advice. The lawyers were asking a range of questions to assess the client's individual circumstances, such as income, disability, and education levels. Triage was unable to replicate this assessment because it was too nuanced and too invasive at the entry level. We shortcut the assessment by identifying cohorts that experience systemic disadvantage, such as disproportionate targeting by police and historical or current experience of harsher treatment under the law. The goal was to prioritise these groups for assistance to mitigate any barriers they faced. The initial list include young people, Aboriginal and Torres Strait Islanders, people with cognitive impairment, intellectual disability and acute mental health conditions, people experiencing homelessness, refugees and people on a full government pension. Similarly, the lawyer's assessment about the impact of the legal problem was far too complex to be replicated at triage because it involved legal assessments of merit and eligibility. What we were looking for was a way of identifying legal problems that always required legal advice, regardless of the client's circumstances. We took the approach of identifying legal problems where the client was at risk of losing a fundamental human need, such as liberty, safety and security, housing, family relationships, or basic income. At its most basic, the triage model directed intake staff to book an advice session for anyone who was a high priority client or who had a high impact matter. Anyone who didn't meet these criteria was referred to information resources. This triage model was trialled in 6 locations, 2 locations for each law type, civil, family and crime, before being rolled out more broadly. It's taken us 4 years, next slide. It's taken us 4 years to get to a fully implemented triage model that is now fairly well accepted by staff at Legal Aid New South Wales. The success of the model can be seen in the 10% reduction in incoming telephone calls across our offices and 50% reduction in client bounce. That is, clients calling one number and being told to call another number. It's also produced better alignment in criminal law, with about 25% more Aboriginal clients receiving advice in crime. Perhaps more importantly, triage has eliminated ad hoc triage systems such as drop-in advice, call caps, which were providing poor outcomes for the clients that needed us most. We now have better visibility of real demand and service delivery across the state because of the data capture at intake. We're also aware of local nuance that affect service delivery that we were not previously aware of at an organisational level. We're now working towards service solutions in those teams to ensure consistency across the state. Next slide. There are some key learnings that help us to continuously improve our model and may assist other organisations considering implementing triage. Number one, keep it simple and aligned to your high-level purpose. Primary triage is a blunt tool and not a precision laser. The purpose is to make sure that people who should be prioritised for legal assistance according to your high-level purpose can get it in a simple and timely way, and also to create capacity by referring some people to information and self-help resources. 2, culture is key. Until the introduction of triage, intake was controlled by the local office and each had their own ways of managing demand. The introduction of triage was a huge cultural shift and produced unfortunate examples of staff calling other staff to tell them why their triage decisions were wrong. We now have intake managers in each office who support local staff doing triage and work together to resolve issues between offices. 3, triage does not stop at intake. Triage is an ongoing process through the client engagement with the legal assistance service. The primary triage, undertaken by intake staff, directs the client to legal advice or elsewhere. And then the lawyer provides advice and fulfills a secondary triage role in determining what level of service the client needs and what the next steps are. So moving the client through that service model that Jane showed you. This multi-layered triage is critical. Fourthly, pay attention to your intake staff. Like many legal aid organisations, we have staff answering our phones and staffing our counters that have historically been paid poorly and are under significant time pressures. COVID-19 has dramatically exacerbated that workload issue. We designed and implemented our triage system knowing it was a strain on that workforce because we had no alternative. They have been the champions of this project, giving us frank and fearless feedback and constantly asking us to simplify and streamline. They have been critical to the success of triage. To anyone considering implementing triage at their organisation, we hope this experience has been helpful and we wish you all the best. Thanks.
Thanks so much, Ruby and Jane. It was a really good and again, very quick overview of a significant change that's been really client-focused and client-centered. So great to see. And I love the concept of a reverse opera house. That's fantastic. So again, I'm just going to remind everyone, if you've got questions, please feel free to put them in the Q&A and we can get to that at the end of the session. We're now going to move on to a presentation by Katie Kelso, the Acting Deputy Director of Family Law, Care and Protection at Legal Aid New South Wales. This was to be co-presented with Bianca Dufty, who's a Senior Solicitor at FAMAC at Legal Aid New South Wales, but unfortunately Bianca's unwell today, so Katie will have to carry the torch on her own. So over to you, Katie.
Thank you so much, Catherine. And that's right, unfortunately, Bianca has the flu, so she's missing in action today. I'd just like to start by acknowledging that today I'm coming from the land of the Dharawal people and pay my respects to elders past, present, and extend that respect to any of my Aboriginal and Torres Strait Islander colleagues that might be joining us today. I'm going to be speaking about the Legal Assistance for Families Partnership Agreement, or LAFPA for short. Next slide, please. I thought it might be a good place to start just by explaining what the New South Wales child protection landscape is. There are 3 key agencies in the child protection space in New South Wales, the first being DCJ, or the Department of Communities and Justice, and they're the agency that are tasked with child protection, including child removals in New South Wales. Of course, Legal Aid New South Wales is in there too, and we provide a number of legal services to parents, carers, and children in care and protection. And the Aboriginal Legal Service is the peak legal service for Aboriginal parents and children in New South Wales. In the current child protection landscape, there is limited, if any, engagement between a family and a lawyer prior to a child being removed, despite there being a number of critical flashpoints. Of course, this current state disproportionately affects First Nations families who have both historically and contemporaneously been subjected to significant and disproportionate rates of child removal. In 2019, Professor Megan Davis undertook a review of case files in relation to over 1,100 Aboriginal and Torres Strait Islander children who were in out-of-home care. And ultimately, in her Family as Culture review, she made 125 recommendations for how the system could be improved. She concluded that early legal advice for parents would support them to navigate the system, to understand their rights, and it would allow them to request support from DCJ for alternatives to removal and to help explore less intrusive options rather than immediate removal. Next slide, please. So at Legal Aid New South Wales, we were really keen to be proactive in this space and see what we could do as an organisation to drive some change within the system. There were numerous reports, reviews, and in particular the FIC report that I've just referenced, as well as the Closing the Gap targets that gave us the perfect platform to start having these conversations with DCJ. And we really wanted to try and drive this change working in partnership with the ALS as the peak legal service for First Nations families, because fundamentally all of the agencies are focused on the same thing at the end of the day, which is keeping families together where it's safe for us to do so. It's a conversation that we began in early 2020, and it culminated in the Legal Assistance for Families Partnership Agreement, which was executed in June 2022. And over that 2-year period, there was extensive and painstaking consultations within each organisation with senior executives championing LAFPA's development and implementation. And it was the first time ever that the 3 biggest agencies in New South Wales in care and protection had been able to do something together. Next slide. So the objectives of LAFPA, the agreement itself is really high level. What we wanted to do is have an agreement that set out the principles and objectives for how we wanted to work together as 3 agencies, and these will not change. Whereas the schedules that are attached to the agreement itself, so the documents that support the objectives, are able to be amended as required. We all agreed it was important to set some overarching principles for how our agencies should work together, and we want to model these from the top all the way down to staff that are working on the coalface. And it was in recognition that we could do better in terms of having mutual respect for each other and better communication. And we all sort of thought that this really stemmed from the fact that usually we're coming into contact with each other in litigation contexts. It's high stress, it's high stakes, and we're all under intense scrutiny in that situation. So the agreement also has some principles that commit agencies to prioritising early intervention with families and also prioritising family-led decision-making and agency. Next slide. So Objective 1 covers off on making sure that there are regular opportunities for all of the agencies to collaborate and communicate regularly via quarterly working group meetings. The working group meetings are to focus on opportunities to work collaboratively and share information, look at training and what opportunities there might be for joint training, and identify and address blockages to implementing the agreement. We also wanted to encourage staff at a local or grassroots level, for example, a local legal aid office and a DCJ office, to make local arrangements for tailored implementation of LAFPA. We really wanted people to have local solutions for local problems to meet the needs of their local communities. Next slide. Objective 2 puts into practice a mandate that families will be advised by DCJ of their ability to receive free legal advice from the ALS and Legal Aid at their very first point of contact with a family and at other trigger points during a family's engagement with DCJ where concerns are raised about the safety of children. And to facilitate this objective, we've developed a referral form that DCJ staff can use to send to us when families want some legal advice. This is the most significant change to current practice and we think has the most potential for genuine change and impact on families and children. What Objective 2 contemplates is that a legal practitioner from a culturally safe and competent legal service will be able to advise parents and enter into discussions with DCJ, working with the family and DCJ to reduce the risk, hopefully to an agreed acceptable level. Next slide, Objective 3. And the purpose of this objective is to embed into practice some processes that we put in place during COVID-19 lockdowns that we found actually really increased the efficiency of what we were doing. We now have electronic service of documents in all locations around the state, and it means we have uniformity in the way we're served with court documents, but also it allows us to have earlier engagement with families who have just had their children assumed into care. Those critical first conversations that families have normally or prior to COVID used to happen in the hustle and bustle of the first day at court are now able to happen outside of that space. And so they're more fulsome and we think they're more effective. We can devote some undivided attention to this conversation. So the importance of this, of providing us with important information up front, again, allows us to have better engagement with families. We know at the outset what support they need. For example, if we know a family doesn't have English as their first language, we can make sure there's an interpreter available. If there are safety concerns, we can make sure we address them before the day of court rather than as it's actually happening. So we like to think that Objective 3 means parents can participate in a more fulsome way in court proceedings and assert their rights earlier. Next slide. Objective 4 is focused on alternate dispute resolution. In a New South Wales context, alternative dispute resolution, or ADR, is mandated within our legislation for families who are at risk of significant harm. DCJ's preferred form of ADR is what we call family group conferences, but that's not a lawyer-assisted model. And all agencies agreed that there were some matters where it would just be more appropriate for there to be a lawyer-assisted model. And an easy example that comes to mind is where there are concerns around domestic and family violence. All agencies agree that ADR is a really powerful tool to give families agency. And of course, we are all probably familiar with the research that tells us that outcomes that are reached by consent have much better chances of succeeding. It importantly allows families to have some agency around which type of mediation they participate in as well. And what Legal Aid New South Wales have done is developed a legally assisted early intervention model of ADR, especially for this project. And that's a model which is flexible in terms of attendance to make sure we can have family members, kin, members of community attend, but also that it can occur really quickly, but also in a safe way. Next slide. So this is a little diagram that is the schedule to the agreement. And the idea of this diagram is that hopefully caseworkers can stick it up at their desk and have an easy reference guide to see when and how they should make a referral to us. So you'll see that stage 1 connects with Objective 2, which is around that early referral. And it gives some pointers about when that referral should be made at what critical points in time. Stage 2 reflects current practice. So when children are assumed into care, then this sets out the process for serving us with care applications. And also stage 3, which is post orders. So when families are impacted by issues around contact, issues around cultural planning, guardianship or adoption, when new siblings are born or restoration is proposed, then there should also be a referral back to us. And we're changing the definition of what early intervention means to include that space as well, because it's still early intervention in the sense that it's pre-court proceedings. Next slide. So in terms of implementation and monitoring, at the moment, it's currently in its trial phase. We have 3 trial sites, and the idea of trialling it there was that we would iron out any difficulties there before we went to a statewide rollout. We knew that it was going to be a really slow start, and that's exactly what we got. It's a really significant cultural change for all agencies, but particularly for DCJ. I think we all needed a bit of convincing that we should be in that space. And so what we've had to do is really work hard on changing the narrative and explaining what the benefits are to inserting lawyers in at an earlier stage. So throughout the course of the trial, which commenced in February, all 3 agencies have continued to come back together to keep looking at where things are working and where things are not working and recommit to the project on numerous occasions. We needed to look forward before we could then, look backwards before we could then look forward. But what we have started to see in recent weeks is a significant increase in referrals, which is really, really pleasing. So we've just got up on the slide, on the next slide, a little case study. And this was from our very, very first referral. And basically what happened in this case is that because we referred a client early, pre-court proceedings, we were able to do all the hard work before the matter even got to court. And on that first occasion, the matter was able to resolve by consent. Everybody had had advice. Everybody had had input into the documents. Everybody was happy. There were happy tears. And in a really pleasing turn of events, our client was, because we had worked with DCJ to achieve this outcome, was able to have a payment made to her of $127,000 in back pay for carer's allowance. So a really outstanding outcome. And that was the very first referral that we received. Next slide. So just in terms of what's next, as I've said, what we have done is continued to try and come together to work through why there has been such a slow uptake in implementing some of these changes. It was very clear from conducting some focus groups with the trial sites that there was a really genuine commitment from all agencies, from people right at the top all the way down to the bottom, in getting this project off the ground. Everybody could see the benefit of doing it, but really what the problem was that we just needed to keep raising awareness for people on the front line and at the coalface, and to support those staff to make those LAFPA objectives become business as usual for them. On a really, really positive note, we have been doing lots of advocacy in this space, and what will come into effect in New South Wales from the 2nd of October is some changes that have also come about to the legislation as a result of Megan Davis's report. And what will come into effect is a concept called active efforts. And what that will mean is that DCJ will be required to establish that they have taken active efforts to prevent children from coming into care. And what will actually be in the legislation and the regulations that come with this legislation is that a referral pursuant to LAFPA for early legal advice will become an active effort, which is a huge, huge thing for us. And we think what that will mean is that we will start to see a huge uptake in the amount of referrals that come through, which is really, really pleasing. Lucky last slide. We wanted to include this quote because we just thought it really summed up what fundamentally this project is all about, and it's from the Uluru Statement from the Heart. When we have the power over our destiny, our children will flourish. They will walk in two worlds and their culture will be a gift to their country. LAFPA provides an opportunity for First Nations families, all families, to exercise self-determination over what happens to their children, who might care for them if they are not able to, and to remain connected to family, culture and country. And that is an overview of LAFPA.
Thanks so much for that overview, Katie. And I will note that Professor Davis that Katie referred to about who wrote the report is also very much leading the Yes campaign and the Statement from the Heart. So it is the same person, in case you're wondering. And she's an amazing advocate on a number of levels around First Nations issues. So just wanted to mention that. Thank you so much, and please feel free to put questions in. And it was really great to see a very open and honest kind of presentation of new ways of working, the impacts that they're making, and also what can be further developed as well. So that was great. Thanks so much, Katie. We might now move on to Gabrielle Canny, who's the CEO of the Legal Services Commission of South Australia. And she's already spoken to provide an overview of the International Legal Aid Group conference, but she will now speak on the presentation that she also gave at Harvard, which is the role of modern communications in providing legal assistance. So over to you, Gabrielle.
Thanks, Catherine. I would like to acknowledge that I'm on the lands of the Kaurna people today, who are the traditional owners of the Adelaide Plains. We recognise that their unique cultural heritage, customs, spiritual beliefs and relationship with the land are of ongoing importance today. And I pay respect to elders past, present, and emerging leaders of the future. And so the paper that I delivered at Harvard was in relation to the role of modern communications in providing legal assistance. First slide. These are the questions. Where do I start? Who can I trust? How can I pay for this? They're the common questions heard across the legal assistance sector, particularly from those vulnerable members of the community who can least afford legal advice and representation. When confronted with a legal issue, a person will be emotionally challenged, and for many, navigating the legal system is filled with fear, anxiety, frustration, confusion, and guilt. Like each Australian Legal Aid Commission, Legal Services here in South Australia is passionate about ensuring justice is available and accessible for all South Australians. That's in accordance with our Act. For legal aid commissions, being client-centric, having the client at the centre of the decision-making process is a high priority. But do we today truly understand our clients, their motivations and expectations? So to answer this question, Legal Services commissioned some research to map the emotional journey of people seeking help from legal issue identification through to resolution. Next slide. The legal assistance sector regularly delivers programs that are aimed at making justice accessible and affordable to all. But too often, the approach is influenced by past behaviours, perceived community need, and reactionary program development. So to test these approaches, the research developed a two-stage method with in-depth interviews used to understand the journey people took before reaching legal advice or help, followed by an online survey designed to quantify findings and to ensure confidence in the resulting conclusions. Understanding the experiences and journeys of people who have sought legal help is an important way of predicting the route that others in a similar situation may take in the future. What was found was that the quicker a person with a legal problem can be speaking to a legal professional, the quicker their anxiety levels will reduce. The research identified that a person with a legal problem will often first turn to their trusted circle for guidance and education. The one unifying factor that leads to a smoother process was the pre-existing awareness that a legal support service exists. Those who were referred to legal services generally made contact quickly, received timely support, and were generally happy with the experience. Next slide. So as illustrated, the first 3 steps of the client journey are filled with trepidation, fear, and anxiety. But once the client advances to step 4 and step 5, where they are speaking to a lawyer, the better their mental health becomes. The client journey has been validated by the National Legal Aid research that Louise Glanville talked about earlier. This includes, as we know, this includes a reduced burden on government-funded mental health services as a result of helping individuals to navigate the justice system, advancing their matter efficiently and reducing potential pain and suffering. Communicating with disadvantaged groups is our core work, but broadening the traditional audience segments through which legal education and information is targeted, as well as the mechanisms through which these activities are delivered, can yield widespread results. Applying the legal services client journey map more broadly across the legal assistance sector, the challenge is to accelerate a potential client through their journey, having them reach step 4 as quickly as possible. But what could the benefits to the community be if the legal assistance sector could reach prospective clients ahead of time, before they knew they had a legal problem, or to provide legal help to those who don't yet know they need it? The COVID pandemic introduced new communication opportunities and changed community acceptance to the way they receive and seek information. Next slide. The pandemic taught us several important lessons about communicating. During the pandemic, clear and accurate information was essential for keeping the public informed and safe. We learned that effective communication requires transparency, consistency, and credibility. The situation with COVID-19, as we know, was constantly evolving and information was changing rapidly. This highlighted the need for timely and frequent updates from health officials and government agencies to keep the public informed. The peak of the pandemic was a difficult time for many people. Effective communication requires empathy and compassion. We learned that it is important to acknowledge people's concerns and to provide reassurance and support wherever possible. But the way we communicated also changed. Social media, as we know, played a significant role in communicating information about the pandemic. We learned that social media can be an effective tool for sharing information and connecting with others, but it can also spread misinformation and cause confusion. At the peak of the COVID-19 pandemic, the public education messaging in Australia was comprehensive and multifaceted, with messages disseminated through a variety of channels to reach as many people as possible. The messaging was developed and coordinated by the Australian government in conjunction with state and territories, also in conjunction with health experts and other stakeholders. To support the call to action, the Australian government and each of the state and territory governments launched dedicated websites that served as the central hub for information and resources, and of course provided greater detail. Next slide. So whilst the COVID-19 pandemic shone a light on the principles of social marketing, this of course is not a new phenomenon. What can we learn from those service organisations that operate outside the legal assistance sector, but have been applying these principles with great success for many years? That was the question we asked ourselves. Okay, how do other industries do this, and how could that assist in the legal industry? Social marketing as a discipline has made enormous strides since the practice was formally launched about 40 years ago by Philip Kotler and Gerald Zalcman. Social media is about influencing behaviour change that positively benefits a primary audience, as well as the broader community, through the delivery of a targeted message. Social marketing campaigns are a common strategy for raising awareness about social problems and have had a profound impact on social areas such as public health, social justice, human rights, injury prevention, as they are leveraged across the power of marketing and communication techniques to promote social good. You will all see many, many examples in your own environment. Social marketing campaigns are cited as an effective strategy for raising awareness about societal problems for several reasons. The campaigns use messaging and communication strategies that are tailored to specific target audiences. This approach helps to increase the relevance and effectiveness of a campaign by addressing the unique needs and concerns of different groups of people. They're focused on specific behaviours or actions that individuals can take to address the problem. They use persuasive messaging and communication strategies to encourage people to make changes to their behaviour. Campaigns often employ a variety of marketing channels and tactics: social media, television ads, billboards, public events, so that we can reach a broad audience. The campaigns are designed to create a persuasive and memorable message that resonates with the public and creates lasting change. To be effective, a campaign must mean that a person intuitively knows where to get information, what the next step is. The principles have been used to help reduce tobacco use, decrease infant mortality, stop the spread of HIV and AIDS, raise awareness about gender inequality, create understanding on the importance of wearing sunscreen, to make drink driving socially unacceptable, and to make wearing a seatbelt, many years ago now, when travelling in a motor vehicle, a social benefit. But how does this apply to legal assistance? In the legal assistance context, particularly for organisations providing general legal advice in addition to their representation services, clients and potential clients need to be aware of the support services that are available, and in some contexts, changes in law that may impact their lives. Knowledge ahead of time with a direct call to action has the potential to create a paradigm shift that might be the difference between a person needing or not needing legal help, through greater awareness of their rights and duties within the law. From a sort of a societal perspective, such activity has the potential to prevent legal problems from occurring, avoid legal problems escalating, and reduce the burden on the justice system by resolving disputes outside of what we know is time-consuming and expensive court proceedings. There are several factors that contribute to the success of a social marketing campaign. I think these ones I'm sort of just reinforcing here: clear and measurable targets, understanding the target audience. It's really important. Who's listening to this? Who am I trying to influence? Creative and engaging content. You've got to hold the attention of the viewer as well. Strong partnerships and collaborations, and of course, evaluation and adaptation. Next slide. What we've also found in doing this work, that brand awareness will impact the acceptance of social marketing campaign messages. When people are more familiar with a brand, they are more likely to accept and engage with the campaign. share it with others, and take action based on its message. On the other hand, if a brand is not well known or has a negative reputation, people are less likely to engage. Therefore, increasing brand awareness needs to be an important part of a social marketing strategy to build familiarity and trust. Brand awareness refers to the level of familiarity that people have with a particular brand or product. Often I think in the legal assistance sector, we think, oh no, we don't need to know about that. We're not a brand, but actually we are a brand. All the legal assistance providers are brands. Whilst this is understandable that we might concentrate perhaps our efforts on the service delivery, we need to take that step back to say, okay, in conjunction with that, we've also got to look at what our brand is and how we're getting out to the community. If we reflect on that client journey mapping that I showed you, increased brand awareness can play a critical role in accelerating a person with a legal problem through their assistance journey to get them to step forward quickly. Increasing brand awareness doesn't need to be an expensive exercise, but it does take sustained effort, it takes discipline, and it takes consistency. Next slide, please. In Australia, for many legal aid agencies, we know there is a defined obligation to deliver legal education programs. Some are under our pieces of legislation, it's a defined task, and for others, it's something that is universally provided because we know the impact. We at Legal Services have been delivering this service over many, many years, mostly through a traditional engagement approach with key target audiences and organisations that support particular population cohorts. Workshops and group training sessions are often used to provide in-depth education on specific topics. These sessions are usually delivered in person, led by a legal educator with experience or knowledge in the subject field. Public events such as expos, community fairs and other community gatherings have also been accessed to reach a large audience with information about a particular issue. These events usually provide for one-on-one engagement for people who are attending the target event. Considerable effort also goes into maintaining printed materials such as brochures, booklets, fact sheets as a cost-effective way of distributing complex information. And that can also be used to leave with someone who is seeking information and can be consumed later. In much the same way as the pandemic reset the expectations within the community on service availability and delivery, the application of social marketing principles also represents the opportunity for legal aid agencies to rethink their engagement strategies. Next slide. I want to give you a practical example now of a campaign. While debate continues at a policy level in South Australia on the introduction of legislation to define and criminalise coercive control as a standalone offence, Legal Services has applied a social marketing approach with respect to growing community awareness of coercive controlling behaviours. Despite the significant harm through isolation, subordination, humiliation and loss of liberty caused by coercive and controlling behaviours, victim survivors are likely to downplay the impact of these controls and are unlikely to seek help if they have not also experienced physical or sexual forms of abuse. Currently, Legal Services delivers a number of domestic violence support programs and services, which positions the organisation as the logical voice to deliver a social marketing campaign focused on coercive control behaviours. Promotion of the services delivered through the engagement of stakeholders, acting as referral agencies, has been the organisation's priority. But the application of a social marketing approach will allow for a deeper message to be created and, of course, a greater audience. Legal Services approach is being produced with the support of the South Australian Government, funding through the state government, and with the recent Scottish experience to prevent and eradicate violence against women and girls being studied closely. What is clear from this approach is that public education and communication was best delivered before introducing an offence of coercive control. The campaign we're running was produced on a limited budget, as mostly legal assistance does, but in partnership with the South Australian Government and broadcast via digital platforms, metropolitan and regional radio, outdoor placements such as street furniture, venue ads. We've relied heavily on our internal expertise to ensure the scripting remains factual and relatable, with the lived experience of victims of coercive and controlling relationships shared with the Legal Services Commission's Domestic Violence Unit and our Domestic Violence Court Assistance Service being incorporated. Further consultation on the campaign's development and scripting has occurred with clients generally and stakeholders providing services across this sector. The importance of the campaign tagline and call to action which was to drive the audience to further information and details to access support, has not been overlooked. We'll go to the next slide. Now, I think we're going to try and play this. Do you want to try clicking on it now?
Hey Jules, hey. Oh, sorry I couldn't make it to dinner with the girls again last night. Oh, Mike says I'm wasting all our money, so I thought I should stay home. Well, he wasn't going to let me have the car anyway. He was in a bad mood because he called me at work and I couldn't answer straight away. And the truth is, he doesn't like me leaving the house without him. Hey, I'm going to have to go. I think he just got home.
Thank you. So that's just a small snippet, and there's many other images. There obviously a male image, female image, different ones, different language, but that's the campaign. Of course, the posters you can see there too. So as a legal assistance sector, there's no disputing we punch above our weight to ensure access to justice is available and accessible for as many people as possible. We deliver important programs and services targeted to help many priority client groups, and our promotion of these activities focused on the clients they are designed to support. But as an organisation, as organisations around the country, we can learn from the last 36 months where our eyes have been open to new opportunities to push the communication boundaries from conservative to innovative. By applying a social marketing lens to our communication plans, opportunities will become obvious where a change in approach can deliver a far greater community outcome and impact. Thank you very much.
So much for that, Gabrielle. We might stop sharing the presentation so you can see all the speakers as we do questions, and please feel free to put in your questions for the panel. I think we will all agree that it was an incredibly rich and very brief overview of a range of really valuable work that legal aids are doing, and also in terms of the system itself. So there's lots to think about, and I think it was a really great display for our international colleagues attending the conference around the work that Australia does and the leadership that we perhaps display in this space as well. I'm going to start asking questions if people don't put some through, but we already do have one question for Katie, and that's from Joanna Fletcher, which is, were you concerned about resourcing implications when you started the early intervention program? For example, how you might staff it while still delivering services where proceedings were being issued?
The short answer is yes, absolutely we were. What we did notice and have been keeping an eye on for some time is the fact that removals have been trending down anyway, and that's been consistent over a number of years, and that's consistent with policies that have been implemented by DCJ. So what we were seeing were less court proceedings, and what we've been saying to our lawyers is that we need to shift our thinking then and keep space in our practices for doing that work at an earlier time, as opposed to focusing so much on the litigation. So yes.
All right, I've got a question for probably all the panel, but perhaps for Gabrielle, just as a starting point. In your overview, you talked a little bit about how there's a shift worldwide or globally from thinking about providing support to people based on vulnerability rather than poverty. And I just wondered if you wanted to elaborate further on what that might mean in the context of, for example, the National Legal Assistance Partnership Review and the current priority client groups that we have listed.
Yeah, sure. I think it's been interesting to be in the legal assistance sector, as I have been over a number of years, just a few years. And when obviously the legislation was introduced for most legal aid commissions, which of course now is 40, 45 years ago, I wasn't working then, but it was all about poor people. It was all about poverty, and it was all about not being able to afford a private lawyer. Whereas, bring us right through to the current, we recognise that people have vulnerabilities and disadvantage on top of the poverty that they also may impact them. And so it has been a shift. I think the legal aid commissions over the last 20 years, and I'm sure other legal assistance sector providers, we've seen the complexity of those clients that we're serving, that perhaps wasn't ever seen by government in the first place when the legislation was set up. When most of our legal aid commission acts were set up, it was all about someone who had appeared in court unrepresented, therefore they needed a lawyer to be appointed for them. Whereas all these presentations today have demonstrated that the complexity actually sits well before they end up in court as an unrepresented litigant. And it also demonstrates how much we can do to assist that cohort at that time. The pointy end of our services still obviously concentrate on that court work because people are at their most vulnerable when they're hitting the door of the court. But there is so much to be done before that. But we can't just look at poverty. We've got to look at all those other categories of client that needs to be considered individually so that they can also benefit from legal assistance.
Okay, thanks, Gabrielle. Great, and now there is a question from Kate Bundrock. Apologies if I mispronounced your surname. Thank you to all the presenters for really interesting discussions. Whether there was just a question around whether there were particular aspects of the Australian presentations which provoked the most interest for the international audiences, and that actually jumped me. I was going to ask Louise that about your paper, but perhaps all the participants could reflect on that.
Thanks, Catherine. I'll start. And Kate, thanks for your question. The one in my presentation that attracted the most interest was the connection between legal and non-legal advocacy. And I think this is this development, I think over perhaps the past 5 or so years, maybe 7 years, really reflects a much better appreciation of clients' experiences and of the lived experiences of those that we're involved in. And this was seen as something quite, in a funny way, innovative. I think Kate reflects the fact that for a long time, funding essentially from governments has sort of been very divided across different systems rather than thinking about the person who might be in multiple systems, and in fact how sort of more not just co-located services but cooperative services can be provided that are going to be helpful to that person's circumstances, whether they're legal or non-legal. So that was the one that was drawing the most interest, including lots of questions about, well, how is a legal assistance commission or a legal aid commission, do you get money for non-legal advocacy? So that was an interesting one as well. And I referred to, as for Victoria's examples, particularly looking at Royal Commissions that have found that there's a need for legal and non-legal responses for people, mental health legal system change, and Royal Commission in Victoria is a good example of that.
Thanks, Louise. Jane, do you have any reflections on what were the key interests in your presentation?
Yeah, we had, interestingly, a lot of interest from Japan and Taiwan in the triage model. And so we've provided materials to them, and we've had some good conversations with them. And we're also participating in some research in Finland arising from the conference. That's about how we've drawn clients into the design of some of our digital entry pathway kind of tools that we're using. So it was fantastic. And I think the other thing, just off what Gabrielle said, was for me the most stark evidence of that move into more sophisticated understanding of vulnerability was the UK many papers, and this will go into Katie's kind of connection too, I think, into the absolute destruction of the social infrastructure in the UK over the last decade or so. Really, stark. That the representation in housing matters, for example, that Gabrielle mentioned in America, talking about that in the UK, where essentially there is no representation in evictions, and just I guess the vulnerabilities around lack of the basics of housing, income, health, those kinds of things. But Katie, you had interest, I guess there was some interest across from the UK around your paper, because there was a really stark paper from them as well.
Yes, Katie, if you want to.
I was going to say that's probably a pretty good segue. I was going to say that I thought that our paper, everybody kind of understood what we were trying to do and why, but the question that kept coming up was how do you actually do it? How do you actually, like, it's a great idea in theory, how do you do it in practice? And I think the answer was, well, I'm not sure we've necessarily figured that out, but we're pretty committed to trying. And so sharing some of the various strategies, I mean, is it a combination? Is it a perfect storm of circumstances? I mean, in New South Wales, there's a real interest in climate, I think, of a willingness to change and do better, closing the gap for us. But I mean, I think we've also been assisted by a group of people in all organisations that are really committed to it. We've tried to leverage certain opportunities to train people and speak about this at every possible opportunity. So there's a variety of strategies that we've kind of used, and really sort of saying to them, like, this is kind of working for us, but, come back to us and we're trialing it and we'll let you know.
Great, thanks, Katie. And Gabrielle, what was the key things that people were interested in your paper?
Yeah, well, it was really interesting because what they wanted to know is what sort of reach, what sort of numbers, what would your expectation be to sort of run a campaign like this? And so I let them know that what the views or the impressions of the digital platforms are projected at over 359,000 views. And so what you could reach that many people through one campaign. Now we will see how we went with that, because the campaign is just finishing up now. What we do know from our early stats is that the website traffic we've identified 30,000 users who access the website during the campaign period. And so obviously we are getting people there. Those 30,000 people are receiving information about what to do next. And so they're people who have identified coercive control in their lives, or perhaps lives of their loved ones. But we will have a full report at the end about exactly what impact it did have.
Great. Thank you all for those reflections. They were really, really useful, actually, and interesting to hear what the rest of the world is interested in as well. This might be a question for perhaps Louise and then Gabrielle. This is just around, I think there was some mention in some of the presentations, and it's also referred to, if you're really interested in the issues paper of the National Legal Assistance Partnership Review, just around the workforce and attracting lawyers to join and work with legal aid. So, Louise, I don't know if you want to start with a comment on that.
Absolutely. Look, I think everybody's aware of the challenges with recruitment and retention currently, and lots of different reasons for that, which I'm sure you all know. We won't go into, but I think that certainly from Victoria Legal Aid's perspective, and perhaps that's the best way to answer it, we're looking at lots of issues that relate to pathways for people coming into the organisation, the type of organisation that you, I think, would desire to be for people to want to stay with you. So we believe in flexibility. We believe in opportunity within the organisation to do different roles. We believe in secondments to elsewhere. So trying to create pathways and career paths for people, as well as additional opportunities that are going to enhance their sort of learning and development. I think there's particular issues, I would say, for the mixed model of legal assistance that we all support broadly in relation to private practitioners, particularly in some rural and regional areas, and the ability to retain people with the resourcing that we have. I think the best examples in Victoria are some of the challenges down in the Warrnambool area and also in the Gippsland areas, perhaps up in Mildura a bit as well, but not so chronic there. And then finally, I think that there is a very significant piece that is for me about governments valuing the work of lawyers. And I think often lawyers can be seen as just being defenders of really of people who are in strife and who are pretty ugly, if I'm saying that. And I just don't think that's true. I see most people that we see have themselves been involved in circumstances in their lives that are very compromising of having a good time going forward. And in that way, I feel that it's essential for governments to look and see justice and justice systems as much more than just the criminal law, and to see the civil elements to it. And the bulk of the work that we know is out there does relate to civil matters, and to see the impact this has on everybody's lives, individuals, communities, society more generally. Yeah.
I think that was a really good end in talking about the real importance of legal assistance and legal aid and the important work that everybody does. And I think that the presentations also displayed the huge depth and breadth of the work that's being done in Australia. So we've hit the 2:32 mark, or 2 minutes over. So I just want to take this time to thank our speakers really, for their time and the thought that they've put into the presentations. They were all very considered and fantastic. So I think we should thank them all. And I just wanted to say that the recording will be available on the National Legal Aid website, and we will let you know when it's available too. So feel free to revisit. But thanks again, everyone, as well, for attending. An hour and a half these days on Zoom is quite an ask. So it was great to see everyone stick around and listen to everybody. So thank you so much, and have a wonderful afternoon. Bye.